Hello and welcome to No Holding Back with me, Susan Estrich. Each week I'll have the privilege of talking with some of the biggest names from the worlds of media, politics, and law. Nothing is off the table. I'll be speaking my mind and encouraging my guests to do the same. Today I'm joined by one of the biggest names in law. He's been a renowned legal analyst. He's also a really good lawyer, I should add, and a journalist. He was a senior legal analyst for CNN, a staff writer for The New Yorker. He's the author of one of the best books I've ever read about the Supreme Court, The Nine, Inside the Secret World of the Supreme Court, as well as American Heiress, the wild saga of the kidnapping, crimes, and trial of Patty Hearst. His commentary on legal issues is second to none, and it's a pleasure, Jeff, to have you on the air.
Hiya, Susan.
Jeff, what's going on? This is an amazing year for legal stories. I mean, what do you make of the conviction of Donald Trump?
Well, I think I was uh, a victim, if that's the right word, of the conventional wisdom about the Manhattan case against Trump, which was, well, it's a legitimate case, but it is clearly an inferior case to the other three, which other three prosecutions which are pending, and it's really just kind of a technical crime. And after following the trial closely, I came around to a different view. I think it was actually quite a serious case, and I think it was really very well tried by the Manhattan DA's office, and sort of what they put on the table of what the case was really about. What was important, and I think the jury got it, and I think anyone who followed the testimony got it, and I found myself thinking, this was a very worthwhile case, and Donald Trump did deserve to be convicted, and it's a serious thing.
He rigged the election. I mean, I was like you. I thought to myself, falsifying business records, it's a case, but it's not a really good case, and it's really a misdemeanor, and it only becomes a felony if you know, violated other laws, and the campaign finance is a stretch. And like you, I was really struck by the fact that this man tried to rig an election.
Well,
And that's a very serious thing.
it is a serious thing, and I thought the smartest thing the government did was start with the testimony of David Pecker. Now, I have some history there because I wrote the first big profile of David Pecker in the New Yorker. When this story was just starting to come to light, before he knew he was under criminal investigation. So he spoke very openly about how he, to me, about how he paid off Karen McDougal to, just to help Donald Trump in the campaign. And what the prosecution did by opening with Pecker was basically talk about how this whole idea of paying to bury embarrassing stories was part of the presidential campaign. That's all it was about. It wasn't about saving Trump from embarrassment. It wasn't about protecting Melania Trump. It was about getting Trump elected president. And what the prosecution did then was talk about what happened with the Access Hollywood tape, which broke, I believe it was October 6th, 2016, and that was a mortal crisis for the Trump campaign. And there was a very clear sense, and certainly it was believed on the part of the Trump campaign, that if there was one more bad disclosure like this, it could sink the Trump campaign. And it was only after the Access Hollywood case broke, that the Access Hollywood tape broke, that Trump and Michael Cohen went to try to stifle the Stormy Daniels case. And it was that money that was paid to Stormy Daniels to keep the election a possible victory for Trump. That's what this case was about. And as you said, that was a very big deal. And it was a very important part of the campaign. And the fact that this money was used for that showed me that this case was, as you said, a very big deal and something very important, and arguably was the money that got Donald Trump elected president. So this wasn't just some technical case. It was a very serious case about something that had great consequences.
So how come he's raising all this money? How come he
Well,
seems to be surviving this untouched? I mean, I thought it was a serious case. I thought Stormy Daniels' testimony was very credible. I thought it was very troubling. I thought Michael Cohen did well on the stand, all things considered. And maybe it's because there were no cameras in the courtroom. I don't know what, but I worry and I wonder why it's had less impact on the public than it has on you and me.
well, I think the jury is out, as they say, on its real impact. I mean, it's still only been, what, 10 days since the verdict. And sometimes it takes things a while to settle in. And there is evidence that it has had some impact, a couple of percentage points. And in an election this close, that is a significant thing. But I think your question really goes to more than the specifics of the case we're talking about. It goes to the state of our current politics, which is just enormously polarized, and a Republican Party that has become very close to a cult of personality around Trump rather than anything ideologically unified. And the fact that his supporters have rallied to him in light of this conviction and have contributed an enormous amount of money, as you point out. I mean, I think that illustrates what's going on in our politics. It's important to realize that the base of the Republican Party, the people who are really exercised about this verdict, that's not enough to get Donald Trump reelected. He needs something more than that. He needs something like the coalition he put together in 2016. And I do think that this conviction is going to make it harder to reassemble that coalition, because he needs more than just the MAGA true believers. I don't want to give the impression that I'm predicting the outcome of the election, because God knows I am out of that business because I was so wrong in 2016. But I don't think you can say yet that this verdict has had no impact. I think that it'll take a while. And the label convicted felon, that's a serious thing in this country. And if that begins to, be a part of Donald Trump's persona, that's going to be a hard thing for him to overcome, when the people vote in November.
What's going to happen with his sentencing? Is he going to get probation or will he actually get jail time?
God, it's such an interesting question. And there are forces pushing in exactly opposite directions. If you look at sentencing for this crime, including in its felony form, as a first offense, most people get probation or some sort of community service sentence that is not jail time. And so that's something that is very much pushing towards a non-custodial sentence. But if you were to look in the dictionary, if there was such a thing for this kind of behavior, it's like, what is the kind of behavior that pisses off a judge and inclines him towards giving a prison sentence when it is available to him? It's exactly what Donald Trump is doing. First of all, he is in effect a prior offender, because remember, during the trial, he was found guilty of contempt, which is a crime in under New York state law. Contempt and in violation of the gag order, that is something that the judge can consider in deciding sentence. Second, in the usual constellation of issues that a judge considers in sentencing, remorse, apology, a promise not to repeat the conduct. Trump has done none of that. He's done quite the
No,
opposite. He's shown no remorse, no sense that that he's going to stop, and that's all pushing towards a custodial sentence. Again, for my prediction, for what it's worth, on July 11th, I still think he will not get prison, but I do think it's possible he'll get some sort of community service, and that will be an interesting thing. And frankly, I think judges don't do community service enough. And I don't think it will be picking up trash by the side of the highway, but something along those lines is not out of the question.
he really attacked this judge, and I actually thought you watched it more closely, I'm sure, than I did, but I actually thought the judge did a good job and that there are no grounds for appeal. What's your take on it?
I think it's very unlikely that there will be grounds for appeal. I think in a hyper technical sense, there is precedent that for how he structured the jury instructions in connection with the enhancement to a felony, where there was a certain degree of non-unanimity allowed in what the other offense was. I think that is something that will be grounds for an appeal. I think it's ultimately unsuccessful, but I think that's the kind of thing that will that will be his best chance. All the sort of big issues like pretrial publicity, like jury selection, I think the judge did a really meticulous, excellent job on those things. And I don't think there's any real grounds for appeal on those. And I think it's important to point out to non-lawyers, it's very unusual for cases to be overturned on appeal.
Yeah.
Criminal convictions. I mean, it just doesn't happen very often. It's not like, well, it's a new trial and we'll see what happens. The vast majority of criminal convictions are upheld on appeal, and that's just something to keep in mind as this process begins.
What's happening with the other cases, Jeff? I mean, it's really frustrating to watch what's going on in Florida. It's frustrating to watch the Supreme Court sit on the immunity case. What's going on?
It's what's so remarkable about the three other cases is they are all turning out to be disastrous for the prosecution, but in entirely different ways. And it again shows the lucky star that Donald Trump was born under, and frankly some good lawyers that he's hired, that has managed to push these three cases, as far as I can tell, to be almost certainly not going to be tried in 2024, if they're going to be tried at all. So I can go through them one by one. They're very different in what's
Tell us
in
what
the
your
problems.
take is on each of them, because I
Okay.
think people are frustrated right now because those were supposed to be the strong cases. It looked like Jack Smith was a capable prosecutor, and they all seem to be falling apart.
Yeah. All right, let's start with what I think is the most consequential case, which is the January 6th prosecution in Washington,
Right.
before District Judge Chutkan. And that's the case where Trump is accused of uh, conspiring to defraud the United States by putting forth fake electors on January 6th. It's important to point out to people who are not lawyers, he's not charged with inciting the riot. He's charged with attempting to provide false documentation to the House of Representatives to certify the election. Trump's lawyers argued in front of the district court that he was immune from being prosecuted after his presidency for conduct during his presidency, that he had a form of immunity for his conduct as president, that he that prevented him from being prosecuted. The DC Circuit That's the kind of case. It's a relatively narrow category of cases where a defendant is allowed to appeal before trial. Most of the times when defendants
Right.
appeal, they have to wait till the case is over and they've been convicted. But this is a narrow category of cases where he's arguing he has a right not to be tried. The DC Circuit very promptly gave this argument the back of its hand and said, you know, it's one thing to argue that a sitting president can't be prosecuted, and that's a legal issue that's never been decided, although the Justice Department has said we think um, that sitting presidents should not be indicted. Whether they can't be is something different. But the DC Circuit said it is clear to us that former presidents clearly can be prosecuted after they, for conduct while they were president after they leave office. The Supreme Court declined to hear that case on an expedited basis. Heard argument of it in April, and here we are in June with no decision. And I think the arguments for Trump are really weak here. It's really been assumed that former presidents can be prosecuted. It's the reason why Gerald Ford pardoned Richard Nixon, because he thought he could be prosecuted for what he did as
Right.
president. And but given the oral argument, I think it's entirely possible that I don't think there's any way the Supreme Court is going to say he's entirely immune and throw the case out. But I do think there's a possibility that they decide that some part of the case might be impermissible and thus send it back to the district court for more hearings, which will mean the case is on a slow boat to nowhere and impossible to be tried in 2024. So I think that case is in grave jeopardy of not being tried in 2024.
Why
Okay,
don't
that's
they
good.
just drop the well, the conduct which is subject to qualified immunity and go with what's not?
Because they don't know what is. I mean, there is no case that there's a civil case, Nixon versus Fitzgerald, which talks about what a president can be sued civilly for, what behavior is permissible to be sued and what behavior is not. But there is no case that says, that draws a line between those. So Jack Smith could wind up dismissing charges that he didn't have to dismiss, or dismissing the wrong charges. And besides, Jack Smith doesn't think any of these counts should be dismissed. So, I can't blame uh, uh, Smith for not taking a preemptive strike against himself. He's got to wait to see what the Supreme Court does.
And what do you think they will do? That they will go for some kind of qualified immunity?
Yeah, I do think that they will, and I think it'll be a split decision. I think one reason why we haven't seen a decision yet is
There's a
that
dissent.
people are writing dissents and concurrences, and it's not going to be a
Clean.
neat resolution. But I do think they will allow some part of this case to proceed, but I think they will order more hearings to be held in the district court to separate out what's permissible and what's not. And that decision will then be subject to appeal to the DC Circuit and to the Supreme Court. So if they do that, if they do anything other than just affirm the DC Circuit, this case cannot be tried in 2024. So that's that case. Then there is the Florida case, which
Yeah.
in many respects is the most straightforward and certainly factually least complicated of the cases against Trump, which is about how he took classified information from the White House after he left office and refused to return it after he was asked and then subpoenaed and then to return it, and conspired with his associates and subordinates in Mar-a-Lago to keep this classified information that he was not entitled to. This case has been assigned to a judge named Eileen Cannon, a very new judge, barely tried any criminal cases, confirmed at the very end of the Trump administration, who is conducting the single worst set of pretrial proceedings I have ever seen in a federal judge. I mean, the only question I have, and I genuinely don't know the answer to this question, is whether she is engaging in a concerted effort to manufacture a reason to dismiss this case, that she is intentionally sabotaging the case, or she is simply incompetent and doesn't know how to bring a complicated case to trial. And it's in fact making a somewhat straightforward case way more complicated than it needs to be. And she has scheduled hearings. She has allowed outsiders to appear, and which district court judges almost never do, to appear as amicus curiae, friends of the court, to argue that the case should be dismissed or should it be upheld. I mean, she is just making this case far more complex than it needs to be, and in so doing, has made it virtually impossible to be tried in 2024. Again, I don't know if she's doing this intentionally to help Trump politically, or she's simply not competent. But either way, it has put this case on a slow boat to nowhere, and there looks to be no way that that case is going to be tried in 2020.
Is there anything Smith can do about it? I mean, why is he
Well, I mean, one of the things
powerless?
that makes this so difficult for Smith is, there is a procedure, as you know well, Susan, called mandamus, where a party in a case before a federal district judge can say what the judge is doing is so wrong that I am going to go to the appeals court in the middle of the case and get it overturned and assigned to a different judge. And so people have said, why doesn't Jack Smith use his power of mandamus to try to get the 11th Circuit, which supervises Florida, to get her thrown off the case? The problem is most of what she has done as it is delay and not decide things. So it's very hard legally to appeal issues that haven't even been decided.
Yeah.
That's what makes Smith's position so difficult, because it would be one thing if she kept making outrageous rulings that were contrary to law. He did appeal one thing she did, and he did get it overturned during the investigation. But it's very hard to appeal a series of non-decisions, and that's why I think Jack Smith hasn't tried to get her thrown off the case, because it's just very hard to do.
And Atlanta.
In Georgia. Okay. This is a state prosecution. It is not in federal court. It's in Fulton County, which is Atlanta, the biggest county in Georgia. And it's basically a case about a conspiracy to overturn the legitimate results in Georgia by Trump and ultimately 18 other 18 other defendants, including Susan. I don't know if you knew, Susan, and just for our listeners, Susan and I know each other because she was a professor at Harvard Law School when I was a student there. And I don't know if you ever knew Ken Chesborough, who was one of the lawyers for Trump, who was actually pled guilty in the Georgia case. He was my classmate at Harvard Law School.
Oh, really?
And yeah, and we both worked for Larry Tribe as student
Right. I
assistants.
remember.
And one of the weird things about Ken, and I wrote about this in an article in Airmail magazine, was that he, has gone through this weird political transformation in recent years, where he was sort of a conventional liberal, working for Larry Tribe, who was a great liberal law professor, and he became this full-fledged MAGA figure and someone who was deeply invested in cryptocurrency and, big midlife crisis, dumped his wife, married a young woman. I mean, it's an interesting, weird story to those of us who knew Ken Chesborough. But anyway, just getting back to this case, I do think that the prosecutor, Fonnie Willis, made a mistake in indicting such an enormous case. It's very hard to bring 18 people to trial. She uses the racketeering law, which there's a famous federal racketeering laws, but many states have parallel laws. There is a racketeering case underway now in Georgia involving some, rappers and murder, but that case took a year and a half just for jury selection. That gives you some idea of how difficult it is to try complicated cases in Georgia. And I think this, even in the best of circumstances, was going to be a very difficult case to bring to trial. However, what happened was some of the defense lawyers, being alert, smart defense lawyers, sort of heard through the grapevine that Fonnie Willis was romantically involved with one of the lawyers on her staff, and argued that this was a form of prosecutorial misconduct that entitled Trump to get the case thrown out. The trial judge, after an extremely embarrassing and excessively detailed hearing, decided not to throw the case out. But that decision has now been appealed, and the appellate court has put a stay, that is a stop, on all of the proceedings in connection with this case, while the appeal of the prosecutorial misconduct issue is argued. And that means this case is also on a slow boat to nowhere. So you have this, the Georgia case with the prosecutorial misconduct issue. You have the Florida case with the recalcitrant judge. You have the Washington case with the Supreme Court deciding this immunity issue. All very different scenarios, but all benefiting Trump by delaying all three cases until after the election.
What's going on with the Supreme Court, Jeff? I mean, you've got this immunity case, obviously, that's very frustrating because the DC Circuit issued a really strong opinion and the court could have avoided it altogether and just denied cert and denied the appeal. It didn't do that. It denied the expedited appeal in the first place. And then you've got Alito and Thomas, who are both ethically challenged, to say the least. You've got a divided court. What's going on?
I'd be interested in your thoughts on this because, I've covered this Supreme Court basically, since the early 90s. You clerked there. You've been a part of the Supreme Court family for a long time. There were certain parts of the Supreme Court that were, I think, above suspicion is right. A fair description. I mean, look, you and I and everyone who follows the Supreme Court has disagreed with the decisions of the court,
right,
frequently. I mean, that's no surprise to anyone. But there always was the sense that these cases were decided on the merits, that, justices saw these cases differently. And what's happened with Alito and Thomas, where both of them appear to be essentially embedded in the extrajudicial world of, conservative activism. That's just not something that was familiar to us. I mean,
No.
You didn't, you clerked for John Paul Stevens. When John Paul Stevens, got on the court in the 70s till he left and was replaced by Elena Kagan, there were no real ethical controversies about the court. I mean, there was, you had cases like, Bush v. Gore, where God knows people disagreed, but no one really thought that the fix was in on any of these cases. It's just that, justices saw things differently. But now, if you have Thomas and Alito voting in favor of Trump in cases about January 6th, which is, what's pending before the court now, two actually cases, not just the immunity case, but a case about the scope of the obstruction of justice statute. How much credibility will that have, especially if they're the deciding votes? Now, it needs to be said, there's nothing anybody can do about this. I mean, the only thing you can do to discipline a Supreme Court justice is to impeach them. And that's
Right.
certainly not going to happen. But, I can't ever think of a time, certainly not in our lifetime, where the court as an institution is in such a perilous state. And it's just, it's really, it's disturbing.
What's Roberts going to do about it? Anything?
I think the answer is nothing. I think the answer is really nothing. I don't think one of the lines that I've always thought was a good description of the Supreme Court was, nine separate law firms. They don't, they leave each other alone. And, the Chief Justice, he has one piece of leverage there, which is he can assign opinions when he's in the majority. Other than that, he's just like all the rest of them. He has one vote, and he does not have any disciplinary authority over any of the other justices. And they are prickly individualists themselves. And if he took Thomas aside and said, can you tell your wife to dial it back a little bit? Maybe he said that, but there's nothing more he can do. And, with Alito, what's done is done. The flags have flown. So, I think a lot of non-lawyers or people who don't follow the Supreme Court think the Chief Justice is sort of the boss in the way that the president is the boss of his staff. If the president has a staffer who misbehaves, he can just get rid of him. But that's not how it works at the Supreme Court. The Chief Justice has very little leverage over the others. And I think Roberts recognizes that. And it's just much as he would like the court to go back to its, ethically calmed waters, it's just he just can't. He doesn't have that kind of power.
One last question, Jeff, because I know we're running out of time. What did you think of Steve Breyer speaking out in his book and his interviews and his going public with his disagreements with the court?
Well, I I think the world of Stephen Breyer. I think he is just as fine a human being as I have ever encountered. I think it was totally appropriate for him to air his disagreements about the results of cases. But the thing I find frankly bizarre about Breyer is that, he continues to insist that it's really good and it's really important that the justices get along with each other, even though they disagree about they disagree about the results of cases. And frankly, as far as I'm concerned, I couldn't care less how well they how well they get along with each other. If they fought like cats and dogs and upheld Roe v. Wade, that would matter a lot more to me than
Right.
being a great big happy family than upholding Roe v. Wade. And Breyer's view that it's an important value to have them all getting along is kind of baffling to me. And I also think he he talks of he just wrote this book about how he doesn't agree with originalism and textualism as judicial approaches. I think he's wrong that that's all that's going on here.
I
I
do
think
too.
there is rank partisanship on the part of some justices on that court, just justices who find a theory to reach the result they want. And Breyer never seems to acknowledge that, and that to me is a little naive on his part.
The partisanship, Jeff, do you think it's just Alito and Thomas, or does it extend beyond that?
You know, your question implies that there is a clear dividing line between partisanship and ideology. I mean, they all have ideologies, and there's nothing
Right.
wrong with that. There are different ways of interpreting the Constitution. Neil Gorsuch has a way of interpreting the Constitution that is simply different from how Elena Kagan interprets
Right.
the Constitution. And I don't think there's an ethical problem with either way. Um, I do think there's a problem with partisanship, which is, delivering results that help, your political side. And that's the real risk with what's going on with Alito and Thomas. Other than Alito and Thomas, I don't really see any evidence of just outright partisanship. I think there are ideological differences, which, I don't think that's an ethical problem at all. But the partisanship, at least as far as I'm aware and as far as I can see, seems to be mostly confined to the two we've discussed.
Of course, two votes is enough to make a difference in all of these cases, and that's what's causing the Supreme Court to lose credibility. I remember Justice Stevens used to say to me that he thought if you thought long and hard about issues, you came to a result that was what the law required. And I'm not sure law works that way. I agree with you about ideology.
Yeah. I think, they're, Justice Ginsburg and Justice Scalia, they had just different views of how the law worked, especially the Constitution. And it doesn't mean that one was smart and one was dumb and one was ethical and one was unethical. It's just different ways of doing it. And I agree with you that I don't think Justice Stevens is right, that it's a matter of thinking really hard. It's a matter of what intellectual construct you bring to the case in the first place.
Yeah. You've been listening to No Holding Back with me, Susan Estrich. Thank you to Jeff Toobin for an amazing conversation. And thank you for all your insights into Trump and what's going on in the Supreme Court. You've been just terrific. Tweet us at No Holding Back FM. And if you enjoyed this episode, please share the link on social media. You can sign up to receive an email when a new episode drops at our website, noholdingback.fm. Thank you very much for listening, and I'll see you next time on No Holding Back.